Supreme Court of India Jagmohan and another versus Badri, Nath and others decided on February 6, 2024 SCC Online SC 108 facts of the case. The respondents, plaintiffs in the suit, claimed themselves to be the tenants in the property in dispute since 1949. The same was sold by the owners thereof to the appellants, defendants in the suit, by way of a registered sale deed dated January 25, 1983. The respondents filed the suit exercising their right of preemption of the sale, claiming that in terms of the provisions of the 1913 Act, they had preferential right to purchase the property. They offered to pay same sale consideration of Rs 43,000. The trial court decreed the suit subject to payment of Rs 50,238 to the vendee after deducting 1/5 of the preemption amount deposited in the court at the time of filing of the suit. The trial court decreed the suit. High Court upheld the judgment and decree. Findings of the court: the right of the respondents/tenants in the property flows from Section 16 of the 1913 Act. It is not a matter of dispute that the respondents were tenants in the property from the year 1949 onwards, where the rolling mill had been set up. The term urban immovable property has been defined in Section 3(3) of the 1913 Act to mean immovable property within the limits of town, other than agricultural land. Section 3(1) defines any agricultural land to mean land as defined in 1900 Act. The term land as defined in Section 2(3) of the 1900 Act excludes any site of any building in a town or village, meaning thereby that the immovable property would be more than the land only or the land on which the construction has already been made. The fact that the property in dispute is located in a municipal area of Jagmohan is not in dispute. The only issue which requires consideration by this court is as to whether the exemption of preemption as granted via notification dated October 8, 1985 would be available to the property in dispute from the aforesaid provisions of the 1913 Act. If read scheme of the Act, it is abundantly clear that the land and the immovable property are two different terms. The immovable property is more than the land on which certain construction has been made. Guidance can also be taken from the definition of immovable property, as provided in Section 3(26) of the 1897 Act, which includes land, means something more than the land. The notification dated October 8, 1985 limits its application for taking away the right of preemption only with reference to sale of land falling in the areas of any municipality. The same will not come to the rescue of the appellants. In the case in hand, admittedly it is sale of immovable property, which is more than the land, as a rolling mill had already been set up on the land, which was in occupation of the respondents as tenants. For the reasons mentioned above, we do not find any merit in the present appeal.